When we are running a business activity in the market, one of the most critical decisions is to devise a protection strategy. But why we have to protect our business asset, in order to preserve our competitive advantages? Essentially for 3 reasons. The first one, to ensure the success and durability of our business, we need to identify the key asset and which key asset are supporting our competitive advantages. Second, because we can exploit commercially those key assets that has been duly protected. And thirdly, because it's the only way to ensure that we can raise capital. Investors are only going to invest in our business project if we have our competitive advantages duly guaranteed and we have all the key assets duly protected. What kind of legal tools we can use to protect our key asset and preserve our competitive advantages in the market? In Block 3, we are going to analyze the different legal tools that competition law, intellectual property law, advertising law provide us with. We're going to talk about patent and utility models. We're going to talk about trademark. We are going to talk about intellectual property and copyright. We will talk about design, and we will also talk about competition law and advertisement rule. Let's use the following example. When we try to figure out how would you design a protection strategy for a company as Apple, what is the first thing you have to identify? Which are indeed the key asset of this company? And we immediately figure out that technology, digital content, image, design, but also business culture and even business model are important key assets for Apple. How can we protect these competitive advantages? Think about technology. Technology will be probably protected using patent and utility models. And apps and digital contents and basic software, probably intellectual property and copyright will be the most suited legal tool. When we think about the image of the company in the market, what we need to preserve that image? Trademark, but not only trademark, also advertisement and unfair competition. Design, creativity, originality. How can we preserve that competitive advantages in the market? We can use design in order to protect them. If we think about business model, is business model a patentable innovation? Probably the answer in many jurisdictions is going to be negative, but we can think about using unfair competition to protect our business model from imitation from rivals. And finally, business culture. Is business culture an asset to protect? We can combine different options to protect them. We can use trade secret, we can rely on confidentiality agreement, we can maybe think about potentially training and internal policies in order to preserve our distinctive business culture. We can summarize these ideas about which kind of legal tools in 2 basic and huge categories: pure intellectual property and industrial property. What are the main characteristics in order to understand them and compare? First, intellectual property is essentially based on the idea of originality, whereas industrial property is based on the idea of novelty. Secondly, intellectual property is designed to protect and promote creative works, whereas industrial property is essentially protecting application to business activities. Third, when the protection provided by intellectual property tools start with the mere act of creation. However, in most of the cases, even if there are some particularities, we can say that in case of industrial property, the protection required and is based on a prior registration. Next, What is the scope of protection in case of intellectual property, essentially copyright? Is basically a protection against copy, against imitation, against plagiarism. When we think about industrial property and all the different legal tools, patent, trademark, or design, we're thinking about a wider scope of protection. And finally, what is the length of this protection? Generalizing, we could say that copyright provides a longer protection. It's weaker, but it's definitely longer. We're talking about at least the life of the author plus a number of years, average of 70 years. In the case of industrial property, the duration varies, depending on patent, 20 years, utility models, 10 years, or for instance, design, 25 years in total.